Mr. Porter, any opening statement with respect to this portion of the trial?
Please, Your Honor, just briefly. Ladies and gentlemen, first of all, I want to thank you. I want to thank you for fulfilling my request that you not turn away, that you seek out a verdict that renders the truth in this case, and face the horror that this case really is, and make a decision as to the guilt or innocence of this defendant. By making that decision, you have now moved us to the next step, where it will be your responsibility to decide what is the appropriate punishment. There's going to be certain evidence admitted by the state that not only includes what you've already heard and the prior conviction, which you're now allowed to consider in aggravation of punishment. As you do that, there's one other step that we talked about during jury selection, and that is the idea of an aggravating circumstance. An aggravating circumstance is something that the state must do in order to show that a case is eligible for the death penalty or eligible for you as jurors to consider the appropriate punishment. And you have to make the finding of the existence of that statutory aggravating circumstance before you can even move on to the penalty consideration. There are a number of them, but the only one that applies in this case is that the state of Georgia has filed what's called a notice of intent to seek the death penalty. That starts this process. And in that, we have alleged that the murder in this case was outrageously and wantonly vile, horrible, or inhuman, in that it involved torture and depravity of mind. That's what's called a B7 statutory aggravating circumstance. Once we've completed the admission of evidence, I'm going to come back to you and talk to you about what those terms mean under our law and what they allow you to do and some of the other concepts about the death penalty. But for now, we want you to remember the evidence that you've heard. We want you to consider it in a new light as we introduce it in aggravation of punishment. And then take the next step. Take the hard step and render a punishment verdict that this case deserves. And we'll be back to talk in just a few minutes.
Thank you, sir. Ms. Moss, anything by way of an opening statement in this phase of the trial?
No, sir, Your Honor.
Mr. Porter, call your first witness.
Your Honor, at this time, the state would re-tender State's Exhibit Number 1,
Okay.
which is the certified copy of prior conviction for cruelty to a child.
Any objection, ma'am?
No, sir, Your Honor.
State's 1 is readmitted.
We would also reintroduce all evidence, exhibits, and testimony from prior witnesses for the jury to consider in aggravation of punishment in this case.
Any objection to that, ma'am?
No, sir, Your Honor.
Admitted and granted.
Your Honor, we have no other additional evidence in aggravation.
Okay. Ms. Moss, would you like to present any evidence in mitigation?
No, sir, Your Honor.
All right, ladies and gentlemen, there are some matters that I need to take up outside of your presence once again. Please remember the instructions I've given you previously, and you can step out with our bailiff. Our jury's out. You're welcome to be seated. Ms. Moss, I feel compelled to mention that, of course, you've decided not to present any evidence in mitigation. There are certain things that I want you to make sure that you've given some consideration to. Certainly, ma'am, you could testify in your own defense and present mitigating evidence, talk with the jury, describe for them what it is that you think that they need to know in fairness about you, your circumstances, or anything else connected with this crime that should be a consideration for them as they decide what the appropriate penalty in this case might be. I also know, ma'am, that your former defense attorneys, your standby counsel, were gathering mitigating evidence over the course of the time that they represented you. I don't know what they gathered or what information it is that they might have, but is there any of that that you might potentially want to present?
No, sir, Your Honor.
I also know, ma'am, that through the course of this trial, you've had certain family members and perhaps others that have been here as supporters for you. Would you consider calling any of those people to testify in mitigation for you?
No, sir, Your Honor.
Does the court need to assist you in any way in gathering any additional information or finding out something for you that might be of assistance to you in presenting mitigation evidence?
No, sir, Your Honor.
Is there anything else I can do to assist you, ma'am?
No, sir, Your Honor.
All right, thank you, ma'am. You can have a seat. We'll go immediately into the charge conference with respect to the penalty phase. As was noted in the charge conference in the guilt-innocence phase, the state presented 22, I believe, requests to charge that the court has considered, most of them with respect to the guilt-innocence phase, although several connected with the penalty phase. The defense presented none. We have a draft version of a charge prepared for you, and it'll get handed out now so that you'll have a couple of minutes to review it. I also have a proposed verdict form, which I'm going to leave up here on the bench. We'll take a 10-minute recess while you have a chance to review the charge as well as the verdict form, and then we'll come back to finalize the case. Thank you very much.